Okay, very good. Davion Murphy is present. Good afternoon. Is it Miss Toomey or Toomey?
I've been called both, but it's Toomey.
It is Toomey. Okay, because I believe I heard Mr. Sonardi, Senior, refer to you as Toomey, and I had been calling you Toomey, and so I just want to make sure I get it right.
I appreciate it.
To the extent I'll remember this entire conversation. Okay. All right. So we're here on, basically the state filed a motion for order in limine regarding improper character evidence. And I already ruled on the YouTube videos that were contained or listed in the motion. And so now we're here regarding the personnel files of Detectives Griffin and McCullough from the Jacksonville Sheriff's Office. And the state did send me a copy of what the materials were. And it looks like there were claims of excessive force against these officers in unrelated cases. And so my question to you is, why is that relevant in our case?
Judge, I believe I also provided the state with basically an employee administrative investigative history for both Officer McCullough and Officer
Yeah, I looked at that too.
Griffin. Okay, so the court has those.
Yep.
The state is going to be planning to elicit opinions from these three detectives. Detective Griffin, who is supposed to be a gang expert in 1200, McCullough, an expert in 6 block, and Detective Maynard, who is a gang expert in the gang of ATK. So how these detectives, and part of being able to offer an opinion as an expert is by gathering information and data and then formulating an opinion. The basis and manner in which these detectives gather that information and gather that data in order to formulate their opinion is derived from cold contacts, which is just approaching individuals on the street, and also traffic stops, lots of traffic stops. So in order to be able to, and Your Honor has discretion, obviously, regarding the cross-examination of witnesses. In order to be able to attack their credibility and the reliability of the data and information that they're relying upon in order to render or reach their opinion, I think it's fair game for cross-examination. I'm not intending on introducing the lawsuits themselves, but I think at least questioning them about the fact that there are these lawsuits that are pending, of which deal with Detective Trey McCullough, Daigle, who is a supervisor of the gang unit. He is the supervisor of both Detective Craig Griffin and McCullough, is my understanding. And Doug Howell is also in one of those suits. I believe it's the second suit, the 2025 suit involving Jamari Brooks. And with regards to Doug Howell, and I believe the state can correct me if I'm wrong, but he was listed at some point in the state's witness list as a witness for the state. And this Doug Howell, who was I believe still is, a detective in the gang unit. There was a big to-do about this detective in the gang unit tweeting, making biased racial tweets, and therefore the public have finding out about this, basically calling for the disbandment of the gang unit in Jacksonville. It also would go to the fact that our client was essentially on the run, if you will, for about 6-7 months. Mr. Murphy was born in Jacksonville. He's very familiar with how the Jacksonville Sheriff's Office operates, how the gang unit operates, how its detectives operate. And it would be relevant to why he was hiding out from law enforcement, because he was afraid. So on those two fronts, I think it goes to the reliability and the credibility of the state's experts' opinions and the underlying reliability of their opinions, which is fair game for cross-examination, as well as relevancy as to Mr. Davion Murphy's being on the run for 6 or 7 months. The state's most likely going to argue that that's consciousness of guilt when it is the opposite of that.
Okay, just to be clear for the record, there were two, looks like there are two civil complaints filed in the Middle District of Florida, the United States Middle District of Florida, and I only see Detective McCullough listed as a defendant, correct?
He is listed as a defendant in the Jamari.
Yeah, in Brooks and both with McKeon Woods?
McKeon Woods in both.
Yes, listed in both.
And Bo Daigle is in Brooks as well as McKeon Woods, the first case.
Yeah, but you indicated, I think, in state, okay, so state, the Detective McCullough is going to be a gang expert with us?
He is, Your Honor, and Bo Daigle is not with the gang unit any longer, he's not in the gang unit at the time. That several of these, I guess, complaints were made. I don't expect that the state would be calling Mr. Daigle in any capacity in this case, so obviously, any of the actions that were just mentioned relevant to Mr. Daigle as one of the persons as the subject of these lawsuits, the state would ask that the court dismiss. As to, would you like me to continue or you want to go?
Well, no, and so Detective Griffin, again, he's just testifying as a gang expert?
Correct.
Okay. And Daigle's not testifying at all?
No.
Okay. All right. Anything further?
McCullough is testifying, Your Honor, but Detective McCullough was also not in the gang unit at the time of the text message that was just brought to the court's attention. I did cite very well-established case law, and for the record, there are no instances in this particular case where Detectives McCullough or Detective Griffin would have had direct contact with the defendant, nor any claims from the defense of excessive use of force.
Okay, so, the case law is pretty clear, and it is as follows: when the matter is wholly unrelated to the case at bar, the evidence should not be admitted, and that would be the Florida Supreme Court opinion, Breedlove versus State 580, Southern 2nd, 605, Florida, 1991. In this case, I'm not alleging, I haven't heard it, excessive force, so that's not the issue. These detectives are going to be testifying as gang experts, so any rationale for this to be used as impeachment evidence for the jury is pretty remote in kind of nexus. So I'm going to grant the state's motion in limine as to the personnel files of Detectives Griffin and McCullough.
Judge, if I may, just for clarification, with regards to the summary or the history of the employee administrative history for these two officers, McCullough and Griffin, there are times where McCullough had to receive remedial training as well as
Right, but for unrelated stuff that's got nothing to do with this case. So even looking at these, the employee administrative investigation histories of McCullough and Griffin, there's nothing in here that has anything to do with anything that's an issue in our case.
Yes,
So,
Judge.
as indicated, I'm gonna grant the motion limiting. Okay, anything further today?
Judge, there was, and I know that Ms. Toomey and I have gone a long way in reviewing the defendant's statements about retractions that we can agree upon. I think we're almost like 95% there.
Okay.
So I don't know if you want to, if they're prepared to address it now, or we did bring the transcript. It's up to Ms. Toomey.
I'm at the pleasure of the court if you
Was there stuff you don't agree upon?
There is, Judge, and I believe that Ms. Toomey wanted some additional material taken out. Is that correct?
Yeah, we went through, the main objection, or the main.
Judge, I did bring a clear copy for the court.
Okay.
Portion of the interrogation that we would want out would be anything said or asked or stated prior to Mr. Murphy being ready to turn in the rights. I believe that ends on page 13.
State what's your response to that?
Judge, I don't believe there's any reason to take it out, and there were, in a lot of the portion while he's in the room himself, he is talking audibly out loud. He's rapping, and there are statements in there that specifically go to consciousness of guilt. I don't want to go into all the language that he uses, but he says how to hide in plain sight, and he has been on the run for months.
And is that him just talking to himself?
Yes, Judge, he's
Oh,
rapping
okay.
out loud to himself, he's talking, it's before, there, a lot of it is when he is alone in the room by himself, but the
Well, that's
audio is
It's not
playing.
interrogation, so why isn't that admissible? Steve?
I would agree. That part's not interrogation.
So as far as that goes, that being the objection, if it's true Miranda, if it's not custodial and it's not, he may have been in custody, but it's not an interrogation, he's talking to himself, so there's no running from, so. Okay,
But with regards to any questions that are asked by the detectives to
well, like what specifically?
anything. And they're really, it's really not even relevant. You want a water or anything, bud? No. You want a cigarette? What kind of water? What kind you want? It's just going back nonsense. It's really just not relevant.
Just state what's your position on that.
Judge, obviously, we do have to show that
It
this
was a
is
voluntary
voluntarily, and they are making concessions to him for bathroom breaks, whether he wants something to drink, whether or not and they do promise that after all of this, they actually do walk down the street to get him, they can't
Okay.
smoke it in there, but they are talking to him and trying to, make accommodations for him.
Okay, yeah, that's admissible too, because that is right, the state's got to prove it's voluntary from the jury. Okay, anything else in the interview?
Did you want to address the ones that we agreed on or?
The
No,
ones that
I don't
we
need
agreed
to- I
on,
don't-
you
You
don't
need to
have
address
Okay,
what you
okay.
agreed on. I am over here to
Just for
to
the
resolve
record,
disputes.
there's no issues.
Just to resolve disputes. Not today's. Okay, well, take a look at it, just make sure, if there's any, and we can address it, you know, we'll be picking a jury for a week and a
I know.
half, so we'll have plenty of
It's just a
time.
few.
That's,
I'm
you
just trying to
guys,
make sure I have all the redactions done.
I can give you one.
you guys get together, just make sure that if there's any other disagreements, let me know, we'll talk about it, but, it should not take too terribly long. So I'm gonna give this back to you, and I'm gonna give the state back a copy of the personnel files of the detectives. And, I'll see you all, Wednesday.